The main topic of this chapter is the legal aspect of selling, buying, and commercial transactions. It sets the stage for understanding the rules that govern these activities. Sale and bailment. These slides introduces two distinct legal concepts. Bailment. This involves temporarily giving possessions of your personal property to another person for a specific reason, like repair or safekeeping. Crucially, you retain ownership. Sale. Unlike a bailment, a sale involves the permanent transfer of ownership of the property of the buyer. This slide highlights the key difference between two concepts, which is sale and bailment. In sale, both ownership and physical possessions are transferred from the seller to the buyer in exchange for money. In bailment, only the possession of the goods is transferred, not the ownership. The bailee, the person receiving the goods, must return the identical goods later. Elements of a bailment. For a bailment to be legally valid, four main things must be present. First one is delivery of possession. The owner, which is bailor, must physically give the goods to the other person, which is bailee. Second is intention. Both people must agree and intend for it to be a temporary bailment, not for a sale. Third one is purpose. The goods are handed over for a specific job such as storage, repair, or transport. The last one is return of goods. The person receiving the goods, bailee, which is bailee, must agree to give them back once the job is done. Condition and warranties. The next section focuses on the terms of a sales contract known as conditions and warranties. Condition. A condition is an essential for fundamental term of a contract. Express condition. A condition that is clearly written down and agreed upon by the both parties. Implied condition. Conditions that are not explicitly stated but are assumed to be a part of the contract by law. For example, the seller has the right to sell the goods. Warranty. A warranty is a minor or secondary term of a contract. Express warranty. A warranty that is specifically mentioned and agreed upon in the contract. The second one is an implied warranty. Warranties that are assumed by law even if not explicitly written. For example, the buyer will enjoy quiet possession of the goods. The difference between condition and warranty. The main difference lies in the consequences of breaking the term. Effect of breach. Breaking a condition is a serious breach that allows the injured party to cancel the entire contract. Breaking a warranty only allows the injured party to claim financial consumptions for damages but not end the contract. Materiality. Conditions are essential to the main purpose of the contract, while warranties are less important. When does condition sink to the level of warranty? Sometimes a serious condition might be treated like a minor warranty. If the contract is not clear about the importance of the term, the court will look at the effect of the breach. If the buyer has already accepted the goods, a breach of conditions can only be treated as a breach of warranty, limiting the remedy to damages. Ultimately, whether a term is a condition of warranty depends on the substances of the contract and the intention of the parties. This slide is about relevant professions and cases. Key laws mentioned include Contract Act 1950, which is govern the general rules for forming and executing contracts. The second one is Sales of Goods Act 1957, which is specifically regulate the sales of goods, including condition and warranties. And the last one is a case law, which is cases like Bettini and Gia help illustrate the legal differences between conditions and warranties. Transfer of property in a sale of specific extant good for unique or specifically identified goods. Ownerships. Property which is transferred when the buyer and seller intended it to pass. This intention is determined by the contract, the behavior of the parties, and the circumstances. The transfer of ownership is important because it usually determines who bears the risk if the goods are damaged or lost. Transfer of property in a sale of unextant goods. For goods that are not yet specifically identified or set aside, ownership does not pass until they are clearly identified as the subject of the contract. This identification process is called escatement. This slide talks about Section 23 of the Sales of Goods Act 1957. The seller can set aside appropriate unexecuted goods for the contract, and the ownership passes when the seller makes these appropriations and inform the buyer. Goods sent on sales or return. When goods are sent on a sale or return basis, the buyer has the option to buy or send them back. They became the buyer's property in two main ways, which is they tell the seller they formally accept the goods, or they keep the goods for time beyond what is considered reasonable without notifying the seller of a rejection. These slides is about right to disposal. The right to dispose of the goods is a major factor in deciding when ownership transfers. In some cases, the seller might keep the right to dispose of the goods, for example, direct the shipment, even after a contract is made until certain conditions are met. This slide about transfer of title, which is focusing on how ownership is legally transferred from one person to another person. Okay, let's we talk about the principles of nemo dat quod non habet. This slide introduces a fundamental legal rule, which is nemo dat quod non habet, is a Latin phrase meaning no one gives what he does not have. In sales, a seller generally cannot transfer a better ownership title than they themselves possess. If you buy something from the thief, you do not get good title to the goods, and the true owner can claim them back. This slide, we talk about the exceptions to the principles of nemo dat quod non habet. The law has created exceptions to protect innocent buyers in specific situations. Sale by a mercantile agent, a professional agent can transfer a good title if they have possessions of the goods with the owner permission and sell them in a normal course of business to an honest buyer. Sales by on of the joint owner, a co-owner can sell the entire property and gives good title to the buyer. Sale under a voidable contract. If a person gets good through voidable, cancelable contract like one based on fraud and sell them before the contract is officially cancelled, the new owner's buyer get a good title. Seller in positions after sale, which is if a seller sells good but keeps positions of them and then sells them a second time to an honest buyer, the second buyer gets a good title. More exceptions. Here are a few more exceptions. Buyer obtaining positions before title. So buyer is allowed to take possession of the good before formal ownership is transferred. They cannot sometimes passes good title to another buyer. Estoppel. If the original owner acts in a way that makes it look like the seller has authority to sell the goods, the owner is extopped, which is prevented from denying the sale later. Sale by an unpaid seller. An unpaid seller who still has possessions of the goods can, under certain conditions, resell them and pass a good title to the new buyer. Sale under other act. This is the last one. So other laws may also provide for valid transfer of title in specific scenarios. There are relevant provisions and cases. Sales of Goods Act in 1957, which is this act provides a specific rules for transferring property and title. Case law. Cases like Roundland and Default illustrate how the Nemo dat principle and exceptions are applied in court. Sale by non-owners. This is that is like summarizing the previous sections about when someone who does not technically own the goods can still legally sell them. Essentials of sale of goods. A contract for sale of goods must have a four key elements. The first one is a goods. Tangible, movable item must be involved. The second one is a price. The buyer must agree to pay money for the goods and transfer of property. The ownership of the goods must eventually pass the seller to the buyer. And the last one is a contract of sale. A valid agreement contract must exist between the both parties, which one is a seller and buyer. General principles of sales of goods by a non-owner. This slide reiterates the core Nemo Duck rules using its Latin base. No one can give what they do not possess. Seller who is not the true owner cannot make the buyer the true owner. Exceptions to the general rule. These slides repeat the same summarize some key expansions to the Nemo Duck rule, which is already covered in the details in slides 18 to 19. So we go to the next slide. Rights of unpaid seller. This is a new title slide. It will cover the legal protection a seller can take it if the buyer fails to pay for the goods. Three important rights of an unpaid seller against the goods. An unpaid seller is a specific right regarding the actual item sold, like the right to keep the physical possessions of the goods until the payment is made. Stoppage of goods in transit. If the buyer becomes bankrupt and the goods are on their way to the buyer with a carrier or something, the seller can stop the delivery and take them back. Right or resale. The right to sell the goods to someone else if the original buyer failed to pay. Right of stoppage of goods in transit. This right is specifically for when the buyer becomes insolvent, which is bankrupt. It allows the seller to effectively stop the delivery while the goods are in the hand of a carrier and regain the positions. Right of resale. If a buyer defaults on payment, the unpaid seller can resell the goods to a new party. If the resale results in a loss compared to the original agreed price, the original buyer is responsible for the differences. And any extra money, a surplus, made from the resale belongs to the seller. Remedies. This is the red slide for the final sections, covering the legal remedies available to both seller and buyers when a contract is broken. Remedies of the seller. If the buyer breaches the contract, the seller can take them to the court for action for prices, suing the buyer for the agreed upon price of the goods. Damages for non-acceptable, suing for financial consumption if the buyer wrongly refuses to accept the goods. Remedies of the buyer if the seller breaches the contract. The buyer has remedies too. Damages for non-delivery. Suing for consumption if the seller failed to deliver the goods. The next one is a specific performance, asking a court to force to seller to physically deliver the specific unique goods as promised in the contract. The last one is a remedy for breach of warranty, for claiming and damages if a minor warranty term is broken.